Hey guys, and good morning. It's Sunday, September the 23rd at 11 a.m., and you're joining me for another Coffee and Colloquy. Now, I have one cup of coffee, I have half of another cup of coffee, and we have some news articles to go over. So, you joined us last week, and if you didn't join us last week, you're joining us this week. What this is basically an hour-long talk show on Sunday mornings because somebody's got to get up and go do things. Where we talk about the legal developments of the week. I answer some questions from the chat, and we continue with everything. You may hear a child in the background. That's because he's unhappy this morning. He was unhappy last night, too. The kid's always unhappy. The child's never in a good mood. So what has happened in the last week in law? Well, Kavanaugh, obviously, Supreme Court nominee Brett Kavanaugh has been accused of I've heard less protesting out of clients. Supreme Court nominee Brett Kavanaugh has been accused of sexual misconduct. I guess would be the way to phrase it. Sexual assault is the actual thing by a former law school classmate in the middle of the nomination proceedings, and it has the legal world up in arms. Dr. Ford, I believe, is the name of the victim, has stated that while in high school, Kavanaugh, at a party, got drunk, held her down, and attempted to rape her. This has obviously tossed a wrench in the nomination gears. However, they're barreling on forward. If you want to ask lawyers how they feel about that, ask a specific lawyer. Don't ask me. I'm not going to argue a case in front of the Supreme Court. Ever. Ever. That'll never happen. My cases don't go in front. Unless there's a landlord-tenant case that is so important, the highest court in the land has to weigh in on the outcome. That will never happen. I'll never be in front of the Supreme Court, and I know this. I'm going to flip that image real quick. Bear with me, because it is annoying the shit out of me. There we go. Now I look like a scumbag who's not reflected. So, yeah, sorry. I woke up, I was up late last night doing a video game stream over on the other channel, and this morning I'm half dead. So the coffee is a big part of today. So without any further ado, let's just break into the legal news of the week and get this game going. If you have questions, put them in the chat. I have the chat up on a corner here. I'll be more than happy to take a look at it throughout the stream. Normally we wait till the last 5-10 minutes to kind of talk to the audience on this. And, of course, the moment that I bring it up, this is what happens. It goes to the lock screen. Because it hates me. It hates me. There we go. First legal news of the week is actually from my jurisdiction, Pennsylvania. It's a sad story. A gunman has shot 4 at a magisterial district justice office, which is our lower level courts. After the shooting, or during the shooting, the gunman himself was killed. It was interesting. Patrick Dodal, the gunman, came into the building for a preliminary hearing on a domestic abuse matter. While there, pulled out a gun, opened fire, wounding 4 people before a Masontown police officer, Sergeant Scott Miller, returned fire and killed the shooting suspect. This is kind of a normal thing. I mean, I hate to say it, but it is. This is the reason that courts have metal detectors in them. When I was a kid, and I think I talked about this a little bit last time. When I was a kid, my father was also an attorney. He still is also an attorney. He wasn't just an attorney when I was a kid. But there was a shooting at the courthouse in my hometown that prior to then, attorneys had always come through and they were kind of waved through the metal detectors. After that shooting, attorneys no longer got waved through the metal detectors. Nobody got waved through the metal detectors. There are non-life-threatening injuries to all the victims with the exception of the gunman himself, who, if you ask me, isn't classified as a victim, considering he was there for a domestic abuse charge, and those guys generally aren't. That's the best way to kill your defense, isn't it? No, I didn't hit her, Your Honor, and to prove it, I'm going to shoot up this goddamn courtroom. But Crystal Dodal had the victim in the domestic abuse case had stated that her husband had wrapped a belt around her neck on August 25th and attempted to choke her during an argument, and threatening to kill her and both anyone else. He was granted a $10,000 bond, which he probably posted a portion of through a bail bondsman, and was free on that $10,000 bond, because people like this, they don't have 10 grand. They don't have 10 grand sitting in the fucking bank. They're going to a bail bondsman. At the preliminary hearing, which I'll explain in just a second. When we go back, I'll explain where this is. As a matter of fact, let's go back right now. At the preliminary hearing, the way it works in Pennsylvania is you're arrested. If it's not a felony charge, and sometimes even if it is a felony charge, they have the preliminary hearing. The preliminary hearing is you go in front of our magistrate judges. The magistrate hears the evidence against you and decides whether or not there is enough evidence to bind the charges over to the Court of Common Pleas, which is our trial court here, both our civil and criminal trial court. Our magistrate system, our magistrate judges are lay judges by the most part. And to explain that, the lay judiciary is basically judges that are not required to have formal legal training. One town that I lived and practiced in this state, the lay judge, the magistrate, was actually a car mechanic. He owned a auto repair shop. Everybody liked him. They thought he was fair. They elected him to the bench. He went to what we call the judge's boot camp. It's a short boot camp where they learn the basics of the law. The idea behind the magisterial system is it's kind of a grassroots court, a low-down, common-level court where people can go and resolve their legal disputes in a more informal manner. Most people who go into the magisterial court, at least on civil matters, don't actually have attorneys. The ones who do, there's an automatic right of appeal up to our Court of Common Pleas. Our Court of Common Pleas being our trial court, which hears all those matters. So you go into the magistrate's court, you sue, the limit's $12,000. You can sue up to a jurisdictional limit of $12,000 right now. You sue for $12,000. You win. The other guy automatically gets to appeal that ruling up to the Court of Common Pleas for a trial de novo. A trial de novo meaning a trial without any consideration for the lower court proceedings. It's getting a second bite at the apple. It's a whole new thing. And at some point, I'll sit down and I'll go over appellate procedure and how appeals normally work and what they mean and the different Latin phrases. But it is 11:10 in the morning, and I'm not doing that this morning. I don't have it prepared. So maybe next week, if there's interest, I'll talk about appellate procedure. But you get an appeal straight up to the Court of Common Pleas. That's for the civil system. Now, the criminal system in Pennsylvania, the way it works is there's, once you're charged, the police normally do the charging. There's something called a private criminal complaint. You see a lot of them in bad checks and harassment and neighbor disputes, things like that. Criminally, people get arrested, and they get charged or summoned to the court by the police. There is then a preliminary hearing where they go in front of a magistrate judge, and the prosecution puts on their evidence. Their evidence is normally a very bare amount of evidence that says, hey, here's all the reasons that we think this guy should be tried. This is why we think this guy should be treated as a criminal and tried criminally for the charges. Most misdemeanor matters are heard in front of the magistrate for trial as well. A magistrate has a sentencing guideline. They cannot sentence anybody to jail time over a certain amount. But at these preliminary hearings, here's how bad they are. A lot of people waive them. The standard in Pennsylvania is very, very low. Hearsay is allowed to come in when they are considering whether or not there's enough evidence to bind someone over to the Court of Common Pleas. You go in front of the magistrate. The magistrate 9 times out of 10 says, yeah, there's enough evidence. They bind them over to the Court of Common Pleas. The Court of Common Pleas then hears the case, so you're actually being charged. There's a real judge. I shouldn't say real judge. They're all real judges, especially because one of them may watch this at some point. They're all real judges. All magistrates are real judges. That is lawyer speak, me saying a real judge. For a judge that has legal training, not a member of the lay judiciary. And then the Court of Common Pleas makes a decision. So this guy was very, very early on in the process. If he was there for a preliminary hearing, he had been arrested for choking his wife. He had been released on a $10,000 bail. He showed up for the preliminary hearing where they were going to hear whether there was enough evidence to pursue the criminal charges against him at a higher level. And then he whipped out a gun and started shooting people. Because that's a reasonable reaction. He is dead now, and The security at magistrates courts. I'm in magistrates courts pretty frequently. I do a lot of small civil work, and magistrates are the court of first impression for landlord-tenant matters. I represent landlords. I represent tenants as well. There's no security at them, and there's none. There's absolutely maybe if the court is in a bad area of town, they have one private security officer who's unarmed, sitting in the lobby with a desk and a login book. But there's no metal detectors. There's no security. There is a sign that says you can't bring guns in here. And then for peace officers, there is a locker off to the side for the peace officers to put their guns in. Luckily, on this day, Sergeant R. Scott Miller of the Masontown Police Department did not have his gun in that locker yet, because he did stop people likely from getting killed in this situation. Turning over to the chat room, there is several questions here. Severe Weather Eddie asks, in this case, is the magisterial court the same as small claims court? Sort of. In Pennsylvania, we don't really have a small claims court. Now, I'm speaking for everything but Philadelphia when I say that. Philadelphia is different. Cities of the first class in Pennsylvania kind of have their own version of the statewide justice system, where they have like municipal court and traffic court, and they have their own makeup. So when I'm talking about this, I'm talking about everywhere but Philadelphia, because cities of the first class get to set up their own judicial divisions, and Philly's the only city of the first class. But everywhere but Philadelphia County, we have the magistrate court system. Magistrate courts are entitled and empowered to hear and decide cases, civil cases at least, which is what we're talking about. We're talking small claims, up to an amount of $12,000. That's the cutoff. After that, you have to bring, at $12,001, you have to bring the case first in the Court of Common Pleas. Now, if somebody sues over, say, $1,000, say there's a $1,000 lawsuit, and they're out there. Somebody goes to the magistrate court and they lose. You get an automatic right of appeal to the Court of Common Pleas, which is our full trial court here. The full trial court will then hear the case and decide it. Now, I say that it's a little misleading to say that, actually. The full trial court doesn't hear the case normally. There's an arbitration limit. When we say arbitration, we're not talking like call Bob at AAA arbitration because your contract says it. We have what we call mandatory arbitration in my county. The limit for mandatory arbitration is you have to be over $50,000 in claim damages to avoid mandatory arbitration. Mandatory arbitration then goes in and it develops like a regular case. You do discovery, you do answer and pleadings. Everything is determined by a judge up until you get to the arbitration point. You certify it as being ready for arbitration, and then you appear in front of a panel of 3 lawyers who are arbiters. And those 3 lawyers hear the evidence, confer, and issue a arbiter's decision on who wins and who loses. You can take exceptions from the arbiter's decision and send it back up to the judge for a non-jury trial. But $50,000 is the minimum. Yeah, you got to have $50,001 worth of damages to avoid arbitration completely. Now, after arbitration, if you don't agree with the Board of Arbiters' decision, you take objections up to the judge. The judge then schedules a non-jury trial. You have to have $50,000 for a jury trial here as well. And it's decided from there. But it's all de novo from the magistrate. So the magistrate can find it in your favor. You can present all of your evidence in front of the magistrate, and then have the trial judge ignore it or not let the same evidence in, because it's like it never happened. It doesn't matter what happened in the court below when you hear something de novo. It's de novo basically means first impression. We are treating it as if this is the first time any court has ever considered this. From the beginning, brand new. Ardrix Blackclaw has asked, is there a minimum amount someone can sue for? No and yes. You can sue for any amount that you want. You can sue for a dime. The line I tell people all the time when I am explaining the difference between the magistrate's court and the Court of Common Pleas is you can file, there is no minimum to file a Court of Common Pleas action. You don't have to be, it has to be over this amount to be in front of the big court, the big boy court, where we all wear our Pampers pull-ups and all that shit. There's no minimum amount. You can file a lawsuit in front of the Court of Common Pleas for $1. You can request the arbiters, do discovery, all that. But you're not going to get very far. You're not going to get very far because there is a legal principle out there. We have a black letter legal principle that has been well held, and it is called de minimis non curat lex. De minimis non curat lex literally translates to the law does not concern itself with trifles. That means that if a judge looks at a case that is seeking like a buck, the judge can say, this is a trifle. This is so small, there is no good reason that this should be in front of my court or any court whatsoever, and we're going to dismiss it. We're going to dismiss it. You may have a claim. You may have an ironclad case for that $1. Or that maybe it's the Loch Ness Monster singing. Maybe the Loch Ness Monster is suing for tree fitting. But the law will look at it and say, there's no reason for it to be here. It's so small. De minimis non curat lex demands that we not waste judicial and court resources on it, and we're kicking it. It's gone. Goodbye. Have a nice day. Does that mean that if you bring damages of $1, you're always going to be kicked? Absolutely not. There's something we call nominal damages. Nominal damages are normally going to be in a situation where you're trying to assert a right, such as enforcing a non-compete. Say you're enforcing a non-compete. What you really want is you want the person who has said they're not going to compete with you, your former employee, to stop competing with you. That's the goal. But you may ask for damages as well. And you're going to ask for normally, like, this isn't a great example because if they made a profit, you can ask for the profit and all that. But maybe you only ask for nominal damages of $1 or a trespass situation. They haven't really damaged the land, but what you really want is a court order saying they are a trespasser, but you ask for damages of $1. And the reason is, especially in tort law and in property law and things like that, you always have to have some form of relief being sought. You have to be, especially in tort law, you have to have actually been injured. Tort law exists to cure injuries to your person, to your land, to your property, things like that. Trespass is actually, it's not a property-based offense. It is a property-based offense. But civilly, it's not what we would consider property law. It's what we would consider tort law, which exists to remedy damage to your person or your property for injury. So you always have to have some type of damages that you're claiming, even if what you're actually seeking is just an order asserting your right to seek those damages so that you can wave it in the air in the future and go, haha, motherfucker, your fence is an inch over on my property. You're a trespasser. But that was a very good question, Ardrix. Okay, so we've covered the shooting. Let's go back to our next story of the day. In advance of Hurricane Florence, the American Bar Association has taken steps and released new ethics guidance for attorneys. This new ethics guidance regards what attorneys should and should not be doing ethically to protect their clients during natural disasters that may close down the law office. Now, last week, you may remember I talked just a little bit about, as Florence was barreling down on us, an attorney in North Carolina who had told reporters that he would be in his office until the wind began to blow and the rain began to pour because he had to make that extra dollar. During natural disasters, attorneys often will get shut out of their offices, be unable to go back to their offices. Maybe they'll lose files. They'll lose a lot of files, things like that. But they won't be able to meet with clients. They won't be able to ask questions. They won't be able to act in the court. And clients can be prejudiced by this. If the court doesn't grant extensions, things like that, it's become more of an issue, especially in the modern times. And I say that because it used to be, what the fuck are you going to do? A tornado destroyed your law office. How is that an ethical issue? The ABA has issued proposed new ethical guidelines and formal ethics opinions saying, hey, it's a brave new world, motherfuckers. Stop faxing shit. Learn how to type instead of dictate because we have suggestions that you need to follow. The very first of these suggestions, one of the most important ones out there, is that during natural disasters, attorneys should not, in this modern age of internet connectivity and backups and cloud computing and software, be so detached from their case files and so stuck in just having paper case files that they are unable to act or advise clients. The ABA has, in this formal ethics opinion, which we'll show right there, stated that attorneys still have an ethical obligation under Model Rule 1.4 of the Code of Professional Ethics to contact clients and let them know, to a reasonable extent, what is going on in their case and how their case is being handled still. There is continued representation in an affected area, meaning that you actually, when you go back in to an affected area and you reopen your office and you continue to work there, you're held to the same ethical obligations that you had before the disaster. The fact that a disaster has happened does not relieve you of any of your prior ethical obligations. And this is actually an interesting one. There is a thing with lawyers where we don't like electric files. We don't like electronic files. We don't like cloud computing. We don't like backups like that. My office, for example, has we have everything on electronic files, but our electronic files are on a non-network connected or a non-internet connected server in the office and can only be pulled up within the office. The reason is we don't want to put your legal shit in Dropbox. We don't want to put your legal shit in Microsoft OneDrive. We don't want to do those things because a lot of those aren't secure. People can get into those files very easily. They can access the client's files, and our duty of confidentiality extends not only to not talking about your case, but making sure others can't gain access to your case. Let me put it this way. If somebody breaks into my office and breaks into my filing cabinet and grabs your paper file, I am not at fault. I have had your paper file locked in my office in a filing cabinet. I didn't walk off and leave it on a table in a restaurant and somebody grabbed it. But if I leave my door unlocked with a sign that says, hey, come and get it, or I leave somebody alone with a sensitive client file that is not a member of the firm and should not have access to it, and they take it, that's my fault. I could be breaching an ethical responsibility because I have an ethical duty to maintain client confidentialities and to protect files that have client confidential information in them. What the ABA has done in the past has issued guidance that essentially says, hey, if you put these files in an unsecure cloud-based service and somebody gets into it, and it's unsecure, there's no authentication, there's nothing like that, it leaks, somebody hacks Dropbox. Because Dropbox itself, the general version of it, is not secure. We're likening that to you putting your file on the table at the restaurant and walking off for a while and hoping no one in there goes through it. That's a huge responsibility because the internet's not just 50 people in an Applebee's. The internet's billions of people around the world, and these sites get compromised all the time. So there have been new standards that are kind of going, hey, when you do that, if you want cloud-based, it has to be secured cloud-based. It cannot be an unsecured cloud-based drive, and that's how you get around that, is showing you're taking that due diligence. You're taking that extra step to make sure there's a secured one on there. Other requirements on this regard, client funds. We talked about last time how easy it was for an attorney to lose their fucking positions and lose all of their stuff simply because they mishandle client funds. The ABA has said, hey, you're not relieved from your obligation to properly use and monitor client funds in your trust accounts because there's been a hurricane. You have to take some type of reasonable steps. You need to have some type of disaster plan in place to make sure that you can still access and use those funds as appropriate. Because, as we talked about last time, attorneys, if you have client funds on trust, it's not your fucking money till you earned it. But new standards coming out there. New standards are always fun. Now, last time, we went and we took a look at a good friend of mine to determine whether he was or was not Twitter verified. It has been 1 week. And it's time to go in and see whether Andrew Rosso has been Twitter verified. As I explained last time, Andrew Rosso is a good young attorney out in Dayton, Ohio. He practices mainly in the area of internet security and what we call cyber law, which sounds like something from an early 90s AOL chat room, ASL, all that shit. But it's not. I swear to you it's not. It's an actual area of law. He's been making his splash in Bitcoin recently. Writing articles for the Huffington Post, their little shit like that. He is now apparently teaching law somewhere, which that fucking terrifies me, guys. I love Drew. Drew's a great guy. but it fucking terrifies me that he is teaching the future generation of attorneys somewhere. But in case you missed it last time, the Andrew Rosso has been trying to be Twitter verified for a long time now to get that check mark by his name so he can give himself some good credibility. I am a Twitter verified attorney, Andrew Rosso, Esquire. And he hasn't. Every time he checks, Twitter denies the fuck out of him. And in the Lawyer Smack chat room, which is the most isolated cantina of the illegal internet, he has been complaining about this nonstop for over a year now, that every time he sends in to try to be verified on Twitter, they deny him. Now, he got verified on Facebook, and he got verified on Instagram. But Twitter is where the rubber meets the fucking road. How do you know you're even real if they don't give you a blue check mark on Twitter? So, once again, on September 23rd, 2018, let's do a check and see, is Andrew Rosso Twitter verified? I love how it defaults to the fucking lock screen. The answer is nope. Nope, no Twitter verification for Rosso. Still not Twitter verified. Not at all. Let's see. What does he have down here? How blockchain technology can help power a new 21st century... Oh, God. How does DC Comics Universe fit into the blockchain space? Read my latest article exploring the potential it can bring to cities across the world. You know, Rosso, that S in a diamond is a trademark. Pretty sure you shouldn't be using it there. It's a bird, it's a plane, it's a blockchain. Oh my God, he wrote one fucking article. He advertised it 5 times. I love Rosso, but he is certainly something special. Patrick Roddy in the chat room says Boozy should try to get verified so he can rub it in his face. Believe it or not, there is a group of us in Lawyer Smack that regularly send off verification requests, just hoping that we will get verified before him. Oh, Andrew Rosso is not Twitter verified. If you're just tuning in, Rosso is not Twitter verified. Alejandro Renteria, what happens if you get Twitter verified before Rosso does? I don't think I meet the criteria for Twitter verified because there's certain things you have to do, and I don't have those things in my profile, and I refuse to put those things in my profile. You know me. You know who I am. You know what I do. And I don't do that. Moving on from Andrew Rosso's lack of Twitter verification, we come to the bane of all attorneys out there, the thing we all hate, and that is the black fucking lock screen when it comes up again on this. And that is PACER. Guys, if you don't know what PACER is, if you've never practiced law, if you're not an attorney, PACER is the federal court's access system to the federal courts. It is what allows the public to log in and review documentation at a federal level regarding cases, the filings, the motions, the pleadings, the orders. You can log in, you get a password, you log in, you can access it. Now, it's not just restricted to attorneys. Attorneys are the ones that use it, but reporters can get them, members of the general public can normally get them. You pull up the documents, you can download them directly to your computer, and you can read them, which makes you kind of wonder that when there's a federal case out there, why is every attorney going, hey, do you have a link to that one, when we could just go in, type in the case number, bring it up? And that's because PACER costs money. PACER costs 10 cents a page for each document. Now, I think they cap it at like $3. Like 30 pages is the max they'll charge you for. But if you have a case file that you're just coming into, and it is 100 documents long, which is not uncommon, or a complaint with 45 exhibits filed with it, or a motion for summary judgment with the same, that gets expensive really goddamn quick. Not only that, you pay for things like pulling up the docket report on it. You're going to pay for pulling up the docket report. You pay 10 cents just to look at what's happened in the fucking case. those fees add the fuck up. Pacer bills, if you're in a firm that does bankruptcy work or any type of federal filing work, Pacer bills get expensive real quick. This has been a bane of attorneys for a while now. We, like my firm last month, my firm had a Pacer bill that was a couple $100. And we've always said that it destroys access to justice to make people pay for Pacer access. And maybe it does. Really, what's important is, while we're worried about access to justice, what we're really worried about is we don't want to pay to look up the things that have to do with our work. Somebody said, why the fuck isn't a set subscription thing like everything else? The real question is, why should that be an acceptable response? There should be no subscription access to justice. Okay, the law is not fucking Netflix. We're not Spotify Premium. Okay, you don't play 1 or 2 fucking songs and then you're acquitted. You shouldn't have to pay $10.59, $29.99, $40 a month to be able to access these court documents and know what is happening in your judiciary, in your justice system, in your court, and in cases that concern you. But, however, even with that, at the local level, when things are brought up on a federal matter in front of the Eastern District, or any district court really, people will say, oh, well, it's just the district court. Fuck that. The district court is going to be the one that's going to hear a lot of these cases right off the bat. The circuit courts may never hear the case or issue a precedential opinion on them. The Supreme Court does not hear the vast majority of cases that come before it. The district court, on the federal matters at least, is where these decisions are made. And it's important that the public be able to access the documentation that's been filed in there. That's obviously not the sealed documentation. As we'll see here in a moment, you can't just take a bunch of private shit and stick it online. Why should someone have to pay to access that? Now, yes, as you are a attorney in a case or a party in a case, you do get one free view. You get one free view on these documents. That means you can pull them up, you can see them, you can access them for free, and you can download them then. But say you have 2 lawyers on the case, and one of them is an older attorney who doesn't understand how to save a PDF from a website. Excuse me one second. Save a PDF from a website. Then the second one is paying for it. The second one's pulling the case and paying for it. It's just that simple. Because you only get one free view. And if you ever have to go back or something happens, or maybe you viewed the document, you didn't think it was important at the time, and you got to go back now and see it, or getting caught up, it's a horrible fucking process. And that is actually why they've proposed eliminating these fees. And it's not only for lawyers, okay? They're not assuming that lawyers can't pay the fee, because here's the dirty secret. If your costs get exorbitant, we're billing it through to you. We're putting it at the end of your invoice as access copying fees for electronic access to federal legal file or something like that. We will bill it through to you. And we'll do the same thing with our legal research subscriptions. If we got to pull a document that's outside of our subscription plan for Westlaw, and that document costs $200, but it is a very good summary of a complex area of law regarding your case, we're going to bill that through to you. We're not just going to hand it off. It's something we wouldn't have had to access if we didn't have your case. But they are now proposing that they eliminate those fees. We talked about this on Twitter earlier this week. The simple fact is, it ain't gonna fucking happen. It ain't gonna happen. The federal government will never get rid of a 10-cent per page access fee for legal files. It's not gonna happen. It'll happen the very moment that somebody injects $100 million or $100 million into the judiciary for upgrading and maintaining these systems on an annual basis. I see people in the chat talking about it costs X amount of dollars to copy pages of documents when I went in to get them at town hall or from the court or things like that. Guys, that is how they fund themselves. That's how your local clerk's office, your pathonetary offices, the court system, that's how they're funding themselves. It's not only through these additional tack-ons on fees. It's through the filing fees for cases. It's through the copying fees for files. It's through the fees charged to access things on Pacer. This is how they fund themselves. A court's not a goddamn business. It's not a business. I can understand you want to cut down on the overhead of the court system and you want to make sure it's decently fucking funded, but justice is not a profit enterprise. The public should not have to pay for this. Now, I understand you want litigants to bear the cost of their own cases. That's perfectly fair. Filing fees, perfectly fair. Copying fees, if you're not a party to a case, I could understand that. That could be perfectly fair. But this isn't a profit business. It's not a corporation. And in recognition of that, a lot of attorneys started using something that's not actually part of Pacer, but uses Pacer because we're fun people, and we always love to find the loophole. You see, federal documents can't be copyrighted. There's a big question on the extent of copyright for legal matters and things like that. But in general, court documents and government documents aren't subject to copyright protections, which has led to RECAP. RECAP is just wonderful. RECAP, which you'll find at free.law/recap. As a matter of fact, this one's so fucking important, I'm going to move my head so you can see it. Takes Pacer documents that have been, if you install it on your Chrome or your other extensions, RECAP will take Pacer documents, and when you download them from Pacer, it will upload them to RECAP under the case files, so that anyone searching that case for those documents can go to RECAP, put in the case number, and locate it. And they'll be able to locate all the case files. They'll be able to locate all the documents that you've seen. Millions of people are contributing to this. Thousands of attorneys, hundreds of folks daily are keeping RECAP running in the background, and it is fairly secure. It does not track where you are or who you are. It just takes the document, adds it to the RECAP archive, moves the fuck on. It's a free resource for looking up these cases. Now, obviously, newly filed cases, things like that, not going to be much help to you. You can't go in, and nobody cares that Joe Smith is suing the government in the bumfuck Oklahoma. But it can be a great resource for big federal cases that are currently in court that you're hearing about in the news that you want to see the documents for. Because I guarantee you, somebody out there who's pulling those files has RECAP, and they are being uploaded to this free archive. The website for RECAP, and this is from law.com. I am not paid for this. This is not a sponsorship. This is just a wonderful fucking resource. And I use it. I use it on when I'm researching things for the website, Lawyers and Liquor and things like that. I use it all the time because it's a wonderful way to get out there and find big cases, notable cases that have been looked up before or talked about very vaguely, where some of the documents aren't out there. But RECAP's website, it's an HTTPS site, is free.law/recap. Okay? free.law/recap. I encourage you all, if you're interested in the court system, you want to see filings and some of the big name cases that you see out in the news right now, get RECAP, search it. You're probably going to be able to find a lot of those documents. And it's a great way to do that and keep yourself informed about important cases in today's news without having to log into Pacer and get an attorney ID and link your credit card and pay a fucking monthly bill. Great way to do it. I suggest it very heavily. And you should be using it. You should, because it is the responsibility of a citizenship to remain informed about what is going on, not only in their country, not only politically, but also within their own judiciary on many, many cases that are currently coming down and being considered. The thing that I like to remind people is the judiciary is not just a branch of the government. It is the last branch of the government. It is the branch of the government that gets to look at all the other branches and say, hey, you can do this, or hey, you can't do this. It is the one that most people will have the most day-to-day interaction with, and that will most heavily affect your day-to-day life on a regular basis. When you get pulled over and you're paying a parking ticket, that is the judiciary. The legislature made the law, but they made it 50 years ago. The police officer, the judge, the prosecutor, and the cases that came before you are what determine your outcome. So we've said that. I've done that piece now. We've had that conversation. And speaking of the judiciary and your day-to-day access of law, let's turn over to the chat room real quick and see. Yes, somebody has pointed out that Pacer is just recap backwards. Yes, it is, because it is a mirror site. Get it? It's not just me who makes the bad jokes. Everyone fucking does it. Everyone involved in law loves those badass jokes. Is there anything else in the chat before we move on to the next story? Nope. All right. And with that, we're going to move on to our next story, which comes out of Connecticut. And once again, this fucking browser. I hate this fucking browser capture. I hate even more what happens during a fucking stream. That's what really pisses me off. Out of Connecticut, an attorney has been sued for malpractice and in retaliation released client files. And not any client files, the client files regarding his client's psychiatric well-being. A Connecticut attorney named Jason Pearl, who had been in practice since 1956. Now, I want you to think about that. This man has been practicing for 62 years. Has been suspended from the practice of law for 2 years. The reason for his suspension, he took on a client's case. The work on the case was somewhat subpar, allegedly, according to his client, Veronica Paracos. Miss Paracos, in 2014, stated that she lost a substantial amount of money related to a condominium association debt that Pearl had agreed to represent her on. The debt amount was about $22,000 and some change, and that Pearl did not notify her about a risk of foreclosure in relation to the case, that the condominium association could foreclose on it. I have opinions, but Pearl did not inform her of it. Now, remember, those are all allegations. Those aren't proven. Those are allegations that this happened. As a result, though, according to Paracos, she lost her condominium and her rental income and has now sued Pearl back in 2014 for that loss. Now, Pearl filed a motion with the court asking that his former client be declared unfit to testify due to her lack of mental competence, and then attached to this electronically filed motion, not marking it as under seal or confidential, which is standard practice when you're submitting documents of these types, her entire mental health records, showing that she was, well, unfit to testify. Now, Paracos, after that, who was not aware of how he obtained her medical records back to 2006, it's called discovery, has filed a complaint with the disciplinary board. The disciplinary board heard it, said that it was an improper disclosure of her medical records, and issued a suspension to Pearl, who, remember, was her attorney, for doing this, for attaching these documents right there. Excuse me one second, guys. Where Pearl was suspended for 120 days for not complying with random IOLTA audits. IOLTA, once again, being lawyer trust accounts. Now, we have a look at the complaint right there, and this is the client's complaint against Pearl. You can find most of these articles over at the ABA Law Journal. That's the primary source we use. I suggest you go in and read it. She was suing him right there for $400,000. Oh, my God. I don't even have $400,000 in my fucking dreams anymore. But this is what we were talking about earlier and last time with attorney competence and the decisions that attorneys make. In Pennsylvania, very recently, the court came down and recognized that because court documents are indeed public records, that we have certain duties to retract information, to mark certain information confidential, and to make sure it's always filed under seal. Now it involves not only all personally identifiable information, but medical records, which have always been filed under seal. And you mark them as under seal You file them in with the court. It's marked as confidential. The only people who have access to it at that point are the attorneys and the parties. We've always done this with family cases here. In many, many places, family law cases are not open to the public. They're just not open to the public. You may be able to say, oh yeah, divorce was issued. They may tell you that, but they're not going to give you the file. A lot of family cases are limited just to the lawyer, just to the client. And that's it. And I have people regularly call me and go, oh, if you go down to the courthouse and pull my file and look at it, and I say, they're not going to let me look at your file. This is a child custody case. They're not even going to let me glance at your file until I'm entered into the case. And I'm not entering into the case until you pay me. So if you have copies of the documents, I'll be more than happy to take a look at them, but I'm not going to enter my appearance into a case to review your case file. But that's a big deal. It's a big deal because court records are public records for the most part. They are. They are accessible to the public. They can be used by the public. They can be read by the public. It's like we were talking about a moment ago with Pacer. Access to court files is important for the education and elucidation of the public at large. So that's not a small deal to have an attorney be suspended for not filing things correctly. Not filing things correctly. And really, the accusation was that Pearl filed this intentionally open to get it on the record. So now, a moment ago, I said something about homeowners fees. And let me be very clear. I fucking hate homeowners associations. I take a small amount of joy every time I am retained to sue a homeowners association. Something in me lights up the second that I get a chance to sue the motherfuckers who tell you that your grass cannot be 1 inch longer than what they have decided is acceptable for the neighborhood, or that you can't paint your own goddamn front door a certain fucking color. Those assholes bother me. And the fact that they can assess fees, assess levies, and in some situations bring your property to a sheriff's sale because they don't like the fact you planted tulips instead of begonias in the front fucking yard fucking rankles me. Ardrix has said that medical records can't be available to the public until 50 years after someone's death. I'm not certain on that one. It may be a HIPAA law. I'm not sure if that is a court regulation because I don't tend to deal with people who have been dead for 50 years. I do know, and this is an interesting fact that a lot of people don't know, an attorney's obligation to protect their client's information does not end on the client's death. We are bound by our rules or ethical duties of confidentiality, regardless of whether you, our client, are alive or not. After you die, I can't go out and talk about the information you provided to me in confidence. I can't release that information. I can't call your relatives and talk about the case. I can't do any of that. Because your right to attorney-client confidentiality survives even your death into perpetuity unless you have otherwise waived it or an exception grants me the right to disclose it. Which has led to some fun situations I have had. Children die where I represented children call me of a deceased parent where I've represented the child and the parent before, and they have asked questions saying things like, hey, mom passed on and we want to know what she told you she wanted done with the property because we have a will that she went to an attorney for 20 years ago, and we know that she had discussed doing a will with you, and we want to know what she wanted it in that will. 9 times out of 10 it's because they never came back and paid me for the will that they don't have one. But we want to know what she was talking about putting in the will because we want to go to the court and try to contest this, and I'll have to tell them I like you, and I'll represent you in the future. But your mother consulted with me, and I can't talk about what she discussed with me in that consultation because her right to confidentiality is still in effect. And I'll say, oh, she's dead. And I'm going, no, that doesn't matter. That doesn't matter whatsoever. Your mother's right to confidentiality survives even her death and continues going forward. Which is a fun fact. Now, like in a future podcast when a news story comes up about confidentiality, and they come up all the fucking time. Maybe I'll look for one next week We'll talk more about the attorney's duties of confidentiality and the extent of them and how far they go and how far they don't go and when I'm allowed to disclose information, when I have to disclose information, things like that. But the important part is the attorney duty to protecting client information. It doesn't die with the client. It stays in effect no matter what. As we're coming up in the last 7 to 10 minutes of the cast here with the news, we'll go over to our last set of information for this week. Coming up very, very soon, and I want you to remember, as I do this, I am not sponsored. Nobody pays me to do this. I want to talk about something because I want to talk about it. But coming up in the next couple weeks, October 4th through the 5th in New Orleans, Louisiana, is the Clio Cloud Conference. If you don't know what Clio is a legal management group, and every year they put on a 2-day conference in New Orleans, Louisiana. New Orleans. They put it on up in New Orleans, where for 2 days attorneys gather and talk about legal tech. They talk about new client management software. They talk about practice tips. They talk about how the internet can be used to build your practice and to move into a brave new area. That's coming up October 4th through the 5th in 2018. Now, last year, a lot of guys from the Lawyer Smack channel went there. And as a matter of fact, I'm going to go ahead and bring up the Lawyer Smack chat right there, lawyersmack.com, so that you all can see what I'm talking about when I say Lawyer Smack. Lawyer Smack is a community ran by Keith Lee of associatesmind.com. It is a leading community for private lawyers. I'm going to use Keith's chat term right there. What we call it is the Mos Eisley Cantina. It's a place where attorneys kind of loosen their ties, sit down, and on the internet talk to each other on a regular basis to talk about the day-to-days of practicing law. It costs like $100 a year to join. They have member discounts, including discounts for the Clio conference. Once again, not paid by Lawyer Slack. I just use it. I enjoy it. I met a lot of people I like on there, and we have become friends over time. But it has a number of member discounts. If you're a practicing attorney, it is only open to people with Juris Doctorates or who have been admitted to the practice of law. If you are a practicing attorney or a graduate of law school, please consider going to apply. People are accepted manually. Applying does not guarantee that you will be admitted to the chat or to the community. People are accepted manually to Lawyer Smack. However, if you pay the application fee and you're not accepted, Keith does refund that back out. And you can trust it because he's a lawyer. Somebody in there saying Captain Eyebrows, which yes, Captain Eyebrows. Captain Eyebrows was a baby lawyer that the Lawyer Smack all kind of grouped together and raised as our own into a fully functioning attorney, which was an amazing story. But the Clio Cloud Conference in 10 days will be going on there. Last year, Keith Lee gave a talk about social media and building connections via the internet, speaking directly about Lawyer Smack and the fucking furries, which he then put out there. You'll see these are all the people who are a part of Lawyer Smack, including Reddit. As part of that, believe it or not, one of the mods of the Reddit AMA is not only an attorney, but an attorney with Lawyer Smack. You're also going to see some of the speakers there. You're going to see our session speakers, our non-keynote speakers, everybody out there who's just really great. Now, I assume that Keith Lee at Associates Mind is probably doing a talk again. You see a lot of names from Law Twitter, a lot of names from the legal tech industry, Law Pay, people at Bennett Law, people that do not pay collection agencies. You're going to see people over from Palace Law. Patrick Palace from Palace Law is going to be out there. A lot of people from the fucking Lawyer Smack and the Law Twitter, if you follow Law Twitter, will be there. I believe it's only open to attorneys. I'm not sure. Was that said? Okay, Andrew Rosso. I thought that said Andrew Rosso for a minute. I was about to go, holy shit. He's not Twitter verified, but he's speaking there. A lot of good people. Now, here's the catch. If you're an attorney and if you want to go, and I know some of you right there are saying, oh shit, lawyers have conventions too, right? There's your prices, guys. This is where we are right now. If you want to go, it's $1,000 for a ticket, and that's just the cost of attending the conference. You do get CLE hours. You need to make sure that they are for your state. That's $1,000 to attend all of that. But yeah, Yeah, that's there you go. That's the fun part. Uh, and it's fun. It's fun, and I have heard it's fun. Somebody said, Boozy, you ought to go, and my response was absolutely fucking not, because I don't have an extra grand sitting in my back pocket at any point in time. I got 4 kids. Who the hell has an extra $1,000 sitting around to do this stuff, right? And by the way, somebody said AD. Yeah, let me be very, very clear. When we say AD, we just mean it's a bar. We're going to a bar. That's what we're doing when we say AD on the Clio Cloud Conference. Somebody had said, why were furries talked about at the law conference? And Alejandro actually did just respond to that, and very correctly. He was talking about how social networking and social media can lead lawyers to discovering communities that they can be a part of, not only legally, but outside of the law as well, and how it can network and how it brings us up in this day and age to a new thing, and connecting with each other. It's wonderful, actually, and it's very, very accurate. I have found a wonderful community through the internet, through actually Lawyer Smack. Not only the people in Lawyer Smack, but if you follow the fucking furry stuff that happened, Lawyer Smack is how I found out about that community. So it's wonderful. And from that community, I've met so many wonderful people, attorneys and non-attorneys. One of the attorneys that I'm very happy to be calling a friend now that I've met several times is Mr. Whipple, who's in the chat room today, who's one of the leading IP attorneys in the Midwest and possibly in the nation. Very, very good attorney. As well as another attorney in the chat who, if you're from furry Twitter, you know him as Buddy Goodboy Esquire, who has become a very close friend and a very, very good friend of mine, as well as other people there. And it's just amazing. That was what Keith's speech was about last year, and it was very accurate, and it was very, very good. Okay, so we're coming up at the end of the hour, so we're going to take about 10 minutes. I'm going to look at the chat room. We're going to see if there's any questions during the chat that you guys may have on anything we talked about today and anything else. However, once again, when we get to this point, please remember, I am an attorney. I am not your attorney. Unless you have been in my office and you live in my jurisdiction, you have met with me and I have explicitly agreed to accept your case, and you have paid me a retainer of my choosing. You don't just get to PayPal me $1 and call it a day, and then sign an engagement letter. I am not providing you with legal advice. The law is very complex, and it switches from jurisdiction to jurisdiction on a number of matters. It is very important that if you have a legal question regarding a specific case, that you contact an attorney licensed to practice in your jurisdiction regarding it. There is no attorney-client confidentiality. There is no attorney-client confidentiality that will attach to any question I may answer or anything you may discuss today. With that said, have at. Mom's afraid she's going to be in my podcast later this afternoon. Okay, thank you, Scarfy. Mark Gold said, I do not pay $1,000 for a 2-day commercial. I think for the people that go, it's more for the CLEs. Now, I looked at it last year. I'm not going to lie. I looked at the Clio Cloud Conference last year. It looked like a fun time. It really did. And if I had gone, frankly, I wasn't too interested in a lot of the stuff they were talking about. I run a low-tech practice, guys. I really do. Like, me and technology don't mesh. I mean, I learn about stuff as we're going along, but it took me forever to figure out how to do scene transitions on Streamlabs OBS, which is just the easiest thing to do in the world. So I run a pretty low-tech practice. But the idea of networking with a bunch of attorneys around the nation and things like that, that made me feel good. I liked that idea, and I thought about going for that. At the end of the day, I couldn't justify it for $1,000. None of the CLEs were applicable to my state without me applying for the state to recognize them. That's just too much goddamn work, and I had other things to do. If they had CLEs that are approved by the majority of the 50 states there, maybe I'd consider it again, because if I could get all 12 of my CLE hours there, CLE courses can be expensive, and that would at least make me say, some of this cost is justifiable because I'm getting my legal education courses out of the way. Alejandro has asked, how is the paralegal situation going? Well, it's going. We'll be interviewing people this week. I don't think we plan on starting anybody until the beginning of next month. But we are interviewing for a new paralegal to help with the work. Mark Whipple says he has a question, and I am now terrified as I'm waiting to hear from Mark's question. Scarfy Conley says, speaking of law, I hope Brett Kavanaugh doesn't get elected. I'm not going to talk politics. We know my politics. I will, however, say Kavanaugh is not elected. Kavanaugh is nominated by the president and confirmed by the Senate. It's not an election. There's no voting here. Mark Whipple says, suppose you have two inventors who are on a patent. They try cooperatively to exploit the patent. In your jurisdiction, is that enough to cause a general partnership to form by operation of law? I fucking hate you, Mark. I fucking hate you. He's asking a direct legal question on patents. Here's my response. I'm not a patent lawyer. I would say if they're engaging in something like that hypothetically, if they're engaging in something like that for a commercial purpose to make money on it together, they're working together on it, that, yeah, the general definition of a partnership under business law, and I say general definition because it is a common law principle. It is a developed principle over time. You have to check your actual jurisdiction to know this, is two or more people who have come together to conduct business forms a partnership. And you could say that would be, or to me, arguable at least, a general partnership. So, are there any particulars breaking confidentiality as an attorney? I'll tell you what, guys. Next week, I will actually look for questions or a news story about attorney-client confidentiality. They're out there all the time. Maybe I'll look through a disciplinary opinion, and we will talk more about attorney-client confidentiality at that point, because it's such a large topic. It's such a long topic that I can't really talk about it in one go. Patrick Rowdy's silly question, is there a tort case about torts? Probably. That's how it fucking works. Mark Whipple said, in my jurisdiction, it's actually statutory. Most jurisdictions have in some way made a statutory definition of a partnership out there, whether it's an incorporated or a licensed partnership, or whether it's been filed with the state or not, on what a partnership actually is. As a matter of fact, I think Pennsylvania actually has a statutory section that defines what is a partnership, but it's a principle. It's a lot of times it's a codification of the common law principle of people going into business together, but I don't know whether that's right or not. Excuse me. I know. Okay. So, if we don't have that many more questions, we got about 5 minutes, and then we're going to wrap it up on the Coffee Colloquy for this week. Moving forward, we will be bringing back LawyersAndLiquor.com. It has been so long since I've written anything for it. I know. I'm sorry. I apologize. I've been working on several different things, and right now it's just a lot easier to sit down once a week and talk to you guys through this, which I'm enjoying this. We're going to keep this one going. I really enjoy the sit down once a week and do the colloquy with an audience. So next week we're going to be doing that. Now, guys, if you have a legal news story that you would like to see on here or that you think I should at least get a look at, please send it over to boozy@lawyersandliquor.com. I do review that email. I do check that email. I do read that email. And that may be how you end up getting that in here. So if you find something that you want to hear talked about on the Coffee Colloquy next week, please send it to my email and I'll take a look at it. Coming up in mid-October, I believe, there may or may not be one because I will be out of town for a week, heading out to Cincinnati for a completely different type of conference than the Clio Cloud Conference. Alejandro Ventario, what is your favorite brand of coffee? Chock full of nuts. I am a fan of chock full of nuts coffee. And guys, if that is it for today, if we have nothing else, well, then I think it's about time that we call it a day. If you do hang around on any of the other channels, please feel free to hit me up on Twitter, at Boozy Barrister on Twitter. Please feel free to send me an email, Boozy at lawyersandliquor.com. If you know about the fucking Badger, the Badger will be back this afternoon over on the Twitch channel for the Badger. But guys, thank you so much for tuning in today. I greatly appreciate it. And I guess that is all for the Coffee Colloquy next week, or this week, and I will see you again next week. You guys have a wonderful Sunday and a great rest of your week.